Real estate transactions are complicated enough, but when you add a commission dispute into the mix, it really gets complicated. Hi, I'm Meredith Caruso, Manager of Member Legal Communications at Florida Realtors. Let's take 5 minutes to discuss a common misconception about the role of the real estate contract in resolving compensation issues. Here's the scenario. A sales assistant feels that they may not receive compensation for a transaction. So they write into the purchase contract that they will receive payment from the listing broker. Problem solved, right? Not exactly. Remember that a purchase contract is an agreement between the buyer and the seller. An agreement to compensate the cooperating broker usually stems from a unilateral offer of compensation placed in the MLS. The listing broker's offer of compensation is binding only if the cooperating broker is the procuring cause of the sale. So what is procuring cause anyway? According to the National Association of Realtors Code of Ethics and Arbitration Manual, there are a number of definitions of procuring cause and several factors that may ultimately enter into any determination of procuring cause in broker-to-broker disputes. At issue are the uninterrupted series of events which result in the successful transaction, or, in other words, what caused the successful transaction to come about. A successful transaction is a closing or executed lease. In the event there is a dispute over the commission, Realtor brokers and MLS participants are required to submit the dispute to arbitration before the local association of Realtors. There is another option, mediation, which is offered by realtor associations to brokers before arbitration in an attempt to resolve the problem. Mediation is an opportunity for the parties to dictate the resolution of the dispute themselves and is binding only when both sides reach an agreement. When mediation is unsuccessful, the case may be forwarded to an arbitration panel comprised of realtors. Generally, the winner of the award gets all of the money, and only in rare circumstances will an arbitration panel split the award between the parties. That award is final and becomes legally binding. When seeking to resolve a compensation dispute, some realtors believe their commission is secure as long as they cross the threshold with the buyer first. This is simply not true. In fact, the National Association of Realtors directive is clear. Local realtor associations shall not decide the outcome of any award based on a rule of entitlement for one single act. They must consider the entire course of the broker's series of events and compare them to the other broker's series of events. A series of events could include locating the property, showing the property, writing the contract, pre-qualifying the buyer, negotiating the deal, preparing the counteroffers, and much more. But there are 3 situations involving a sales associate's actions or behaviors, or the customer's perceptions of those actions or behaviors, that could complicate the situation. 1, the sales associate wasn't available to answer the buyer's telephone call. In some cases, a case is made that the sales associate abandoned the buyer, or at least the buyer believed he was being abandoned. 2, the buyer abandons the sales associate to work with someone else. And then finally, 3, estrangement. The buyer is turned off by something the sales associate says or does. The hearing panel determines which party is entitled to the commission based on the preponderance of evidence. If you find yourself headed for arbitration, be prepared with evidence and testimony that supports your role as procuring cause. If you are concerned about a commission dispute, speak to your manager or broker immediately to determine the best course of action. Good luck.